Okay.
As at Friday, no my kind. As at Thursday, no my kind 30 pages. Friday, maybe I love it for my breakdown. No my kind 48 pages. My team me could do if you bear one. And I'm meeting me kind of cram me da bear 1 hour been a media ban. So but me who a summary by Professor Kwekwaza, and I think that it makes perfect sense based on what I usually to have read.
Okay.
That does not mean that lawyers, you can give them 2 provisions of the Constitution. The interpretations will vary. So that is his interpretation, and that is an interpretation I usually say to agree, having read the judgment myself.
Okay.
I don't know what
yes.
So let me issue that caveat so that someone will not come and say that and I don't want to take credit for somebody's work. It's not my right. But Abraham Madam Sedina Tamakloe, he was acquitted and discharged, and acquitted and discharged basically and say she cannot be charged for the same offense.
Okay.
Yes, sir. If you be left in a double jeopardy, yes, sir. It's the law of natural justice.
That's right.
You cannot trial the same person on the same charges twice. The court say acquitted me yam.
Okay.
Say be a discharge, say be a there be charge sheet the defendant and cobra. But to acquit and discharge me you go say be some viewer me yam.
Okay.
I will explain why.
Okay.
Na 2 attorney once a man for blame Godfrey so be true statement me me blame way. I don't think me view say u blame mienu na eyeye. I also explain the document why me dream say. You see there be am jam me kase me say oral cases no. Oye attorney general deputy obetumi akasa na okasa. But at the end of the day, the person to give the verdict to weigh the evidence you presented and what the accused person has equally presented will be the court.
Okay.
Mamu example, me YouTube channel the critical analyst. And I can say Hanan Okaya judge rule what kind letter no. Said in Qatar any problem on Kwabuchiri.
That's right.
That's what the judge said. What do you want the attorney general to do? But say Qatar nani it will go UK. The judge granted.
Judge Amano Quine.
Enti no say wo bufu na ka say bia attorney general Godfrey Dame and I say ayenia mimi you say to them again say e far fetch.
Okay.
Because they will present a case. The case is for someone to decide. As in FM who to me. Say you never say come here never but the decision in me ho. It's one listen and blame say you adwuma. I don't take that decision. Kuku say could take that decision.
Yes.
So the one who takes the final decision in my view should be the one you question.
That's it. And it's very important say Nippon a court system now.
Exactly.
And until the can say Abaya Jai Sedina.
Yes. But me blame one because none be.
Okay.
You can
be. That's right.
Baby, I said, look at Yago Car, the jam. I'm going to say, I won't say, because I knew. Because it's Sicilian. And then make us a mere surprise and me,
that be.
Me surprise and every man said in that Tamakloe. Why can't I not pay crime to see a bit me, because then now, stay of execution, I pick what I'm very really.
Yeah.
The battle at
sure.
It's in a yeah, drained it. Today, I make us say, ya drink, Mamma, another double. Dennis Miracle. You are no closer to Dennis Miracle than me, you but make us say, prosecution, why? Because the then is called quarter. And when you be the brief fact of the case.
Sure.
Say the then is at the end 5.2. You could say 55. Deputy Attorney General Crasso, no more bank card a brosa. Mebois. By a quarter. And I'm pretum shirt your black. I'm pretum shirt your white. Yes, I'm pretum your rasta. Yes, I'm pretum your tuntum. A quarter. Brief fact of the case. The one you be one.
When you can't 70 years.
Yes. And when I me say, and I will say, and you buying me penny say way and a fact. Exactly. And you can't prosecute to be and yes, then is called jail and answer so much jail. Me you do say to now the view that's what could jail. And obey me could I want to make into how we how there's no bearing on my life. But so who person who no crana court I know the positives of it. When the matter goes to court, when I charge you also have opportunity to
defend yourself.
Evidence.
That's right.
But you see, Sedina Tamakloe, when I was reflecting on it this dawn, I said, "Me yati OSP I say in the Kenofria Tamata."
Oh, okay.
I can't true to mommy. Say metros. I said, "Me yati OSP taxes be an offer for ye Kenofria. The bro so person use one tias your warm run. Me yati I say. And let's not forget the wound to me trial.
Yeah.
when Judge Audrey Kokuvite said that won't to me no masimbi. My memory example said in the fee. On ama Henry Okumson Koye Galamse Debbie make us one inquire reclamation.
Yeah.
Oma Nisika Debbie. Also on could be a kube so 10-15 years near Tikubeni at Tom. Kubesi get me reclamation. It's Oma a reason.
Yeah.
But deducing from the reason in the view of the judge, the trial judge, it doesn't make sense. Now let's go to Professor Azanse. And me also I think the international for blame year ago Dominic Kayen and I am letter on the band. Sometimes I throw letter and so I'm careful. TSM will say the attention of the Attorney General has been drawn to the decision of the Court of Appeal acquitting the former master. Now, okay, so your attention has been drawn. You say to two. A German so na mini ha. It is okuku se kuka na mkasa my attention has been drawn to her. But where they won't mean kasa because you are party to the case.
Yes.
It I think so almost some phrasing of letter no a problematic akra.
Yeah, me say but what is some?
Yes, let's go to the substance of Sedina Tamakloe.
Okay.
First issue ni about Tampa microfinance. Must look more mobesia 500,000.
Okay.
No this kind of coin no about Tampa for say interest na mode to so no prosecution case na mebo ne to fa kire ana se na so muntimi dwam fam sika mra me ana court prosecution de go free so no ko twen no bacho na total to mo de sika na ma no ana batampa chairman ne say madam sika de ma ha de me serew me hia letter bi e kire se why den waji sika no according to prosecution omu ko bu no letter no obatampo for de wo ho iyoko de no ayira but sa sika na madam said that time on 5 occasions actually ta come obatampa say monfa interest ya den na sika waje wadi in oguso toilet say we hear interest that is one.
Okay.
The second case in here sensitization bia ye twa abo 1.8 million 1.7 million dollars man no ekowie no 1.7 million cedis ekowie ase no na o ma spend 1.8 million cedis na 10 regions then 16 regions so we just about 3 regions Accra Brown half I think voter region ni akan o manye and also charge them to scan misappropriation. Unse ba we mu dia ye nka no TV.
Yes.
And one brofo ne sophisticated misappropriation. And a second one is a cantamanto fire victims on 579 million. What's happening to me? 800,000 Ghana cedis.
579,800.
800. They just talk market 2015. Siko fen kom wo mu no. Yesu di sika no. Again okoto cars because na ne bo no esusu ebu on so amfa public procurement authority unsa wo koto aban ade bia na so de ko pp no muhwem e kroje bibia no so anya saade again let's gas be otutu man hu mobile phone bi okoto se mobile phone ne 50 cedis a oton ne 70 cedis saade ni nyina account nom de ye the court no this is basically what the court said on all the matters. Let me just summarize for you. Court on the case said charge sheet near the man no e defective. Now let me explain the charge sheet. Unse the court was basically saying say a charge now the boss says okay account be a conspiracy to steal. What ingredients are you basing on to say that there was a conspiracy to steal? You can't conspiracy say many am prechuma na pay prechum microphone e de koduma ye benya bu sa Eugene oh okay me kura me hu say CCTV no mu dum ne be 10 nti e boten na hyiamase woni emetumi you no conspiracy me no wako na krana
yakoye kanana
say charge sheet no na sa boni Sedina Tamakloe dia what the money laundering to no so what the stealing it to no so what the causing financial loss to no so what the willfully causing financial loss to no so I can nyina bo mekoye 78 charges no e to masuma enye charges is defective again no hold this say eba burden of proof so what can send them koto bibi only authorization from public procurement authority the onus lies on the prosecution and the one making the allegation to prove say no new authority no and shift bad and then cause the name was say yes say we new authority to one betrayal authority and as a new authority so the burden of proof per the appeals court at all material times was on the prosecution to prove that she didn't have the authorization now yanko enema 7 na mebo man yanko ba bia so the court found serious evidential proof about Tampade. The original acknowledgement letter was not produced. The document tendered was a copy obtained from Obatampa. No corresponding master copy was produced. Evidence Even though the reference number on the letter suggested that Maslow should have retained a copy. Also, quite a bank copy. Let it be our date, yes. Numbers.
That's right.
Or but Tampa will let any bomb call Maslow. Let any be. Now, the Maslow official who testified has not seen an official Maslow copy against which the documents could be compared. The chairman of Obatapos who claimed that he had exchanged WhatsApp messages with Sedina concerning the refund, those messages were not produced. Obatapos, ministers can come in Sedina bonkomo, mame, mediabo, scano kaya soon. Can some for WhatsApp message, mom, or want me a message in your day. But let's not forget that at the appeals court, they will not sit over new evidence.
Okay.
They will not allow you to bring in new evidence.
That's
except
right.
in extremely exceptional case.
Right.
They were only assessing the facts as presented and ruled on at the lower court, which is the high court.
That's right.
It means a question I come one and say senior. The court when they said now funny because they couldn't prove receipts. Because now Ogusu demand this kind of from about Tampa, which means now on knees can in the view of the appeals court, yeah, 500,000 anyway.
Anyway. And what about Tampa now
said now. So I think that even though she's been acquitted and discharged, and the only route is going to a Supreme Court,
there are still questions to be answered.
There are still questions, and maybe some civil matters must be considered in this matter. That is maybe view.
Sure.
Because there's no establishment of the whereabouts of the 500,000. And the 500,000 you crazy. 5 billion. And where you come back 10 years ago.
And easy.
See, but what?
Sure.
TFN2. Now, the issue about sensitization. Or say, the prosecution's case was that the program neither did not occur or occurred only on a very limited scale. The court held that the prosecution did not prove beyond reasonable doubt that Sedina stole the money. The prosecution did not call the relevant regional officers or beneficiaries who could give direct evidence about whether the program took place or not. Instead, the trial judge expected Sedina to prove that the funds had been properly used. The court held that this again wrongfully transferred the prosecution's burden to the accused. It's burden of proof now, or say. In case 10 regional chairman, form chairman, directors of master from operation voter for musica buy program na benefit on number one man fresh microphone would blame the man Sedina Tamakloe. But you see, there's a phrase in here. Or say the prosecution did not prove beyond reasonable doubt. In criminal trial, you must prove beyond reasonable doubt. That's a sensitization.
So
again, almost also can say countermand of market fire. No. Almost say one prosecution witness admitted that enquiries had established that the funds had been distributed to the victims. Another witness had confirmed this to him, although the information was omitted from the report tendered in evidence. The court held that this admission struck out the foundation of the stealing charge. If the funds had been distributed to the intended victim, the allegation of dishonest appropriation could not be sustained. The conviction and sentencing related to the countermand funds were therefore some say Stekano could be a dancer. Oh, you should share microphone be a tweet.
Stekamo
could be a dancer. This is Nipa no say yes car.
Neither they are saying
the same to be here. But the court also is not telling us. Yes, you can pay to some people.
Yes.
One prosecution can testify who were paid and how much they received. Now, say, unfortunately, at the appeals court, they are not at liberty
to do certain things. Yeah.
Now, I say, what happened to the money laundering conviction? TI very important to say they were set aside. The allegations stealing offenses were the underlying or predicate offense. Say. How do I explain supporting the money laundering members charges? In simple terms, the prosecution first had to prove that the money was the process of an unlawful entity. Before someone can launder money or steal money, it must be from a certain unlawful act.
Yeah.
If that unlawful act is not proven, the person cannot launder or steal the money.
Okay.
And this is basically the summary. Court no money to go here. That's basically the summary.
Not just say you can't say money. Money laundering. Now say it me chima you say baby and dependence can free no. Enya kwampaso. Now when timi anchirem say enya kwampaso a untimi kasa nipa no why money laundering. Why money laundering? And again no money laundering an element is bia sika na kwampaso. But the one who transfers can ni ma bia wodi ye ne baby a wode fifa. And so emfa mramu. And so timi fa ba kwaso no so money laundering.
Now court no ba cast no cast na mo cast Sedina Tamakloe koto ya mo charge no ho. MPP are buying the Kenufreta and between.
Okay.
They renegotiated and paid.
Okay.
It they all not sign contract. So that's also my issue. If you're saying that someone paid, the contract is a binding contract. They renegotiated and paid. But who signed the contract?
Who signed it?
So I think that yes, she's been acquitted and discharged. That is the law. I'm not a lawyer.
Yeah.
But I think that commonsensically, they've raised some questions, in my view. And I think that you and I have debated on the matter. But let me skip. Attorney General saw call Supreme Court a seeking review of the matter. And now, Happy Court transfer for the stay of execution, it means you need free prison. Yeah. I'm fat. Almost on court, conclave 2 hours on by decision to me. But the reason why I can't say, I think that the blame on Godfrey Yabo Adame and Attorney General is that the case was handed over to Dominic Ayene. When they were defended, in fact, when you read the entire 43 pages, we need time. When you read the entire 43 pages, he mostly argued the same point Godfrey Adame argued.
Okay, because at the same fact, no general so
the same fact. And in fact, what's here the body language of the Attorney General when he did the government accountability? You don't know your CRC report.
Yes.
No, 2 minutes.
Yes.
Look, I'll say, even the court in the US.
Yes.
When they were presented with the evidence, believed in us and extradited Sedina Tamakloe.
Yes.
So he is unhappy with the appeals court. And he had, in fact, I think that posture shows that he's very, very unhappy.
Sure.
That's my view. You're entitled to disagree.
Sure.
But the reason I think it's not fair to blame them is something. You see, when they wrote, after the appeal came to the attention and everything, that Attorney General had to write. And senior, my kind court document, I think that that's one of the most strongly worded statements that Attorney General be.
That's right.
Standing by the fact,
decisions,
the conviction of a former Attorney General.
Okay.
It's me can't go for that response here be or see o ma me no na wo me aso obo kind Attorney General yam na ma a bit uncomfortable kakra. Because I don't see where the Attorney General did the state wrong, and I'll read it for you.
Okay.
Because my country is chef and me view what the facts say.
Sir.
Now let's try there. Or say this is the Attorney General speaking. Already see preliminary objection. Whether it's the state attorney or whatever, they prosecute on behalf of the Attorney General. To get it is clear.
Yeah.
Even now the OSP, ya catch us on baby
it's Attorney General
of the Attorney General. Okay. Now say my laws, the antecedents to this case point to the fact that Sedina, make appellant to Sedina Tamakloe.
Okay.
Herein was tried and convicted in absentia. She was sentenced to 10 years, but remained a fugitive. Because I said, "Nama Ghanaian, Mumubiza Montiasian, where Attorney General Neka say, remains a fugitive from justice, and as such has not served even a day of the sentence imposed on her by a court of competent jurisdiction.
Yeah.
Our criminal justice system has been marked by a persistent effort to balance the coercive power of the state and the fundamental rights of the individual. Or see, Ghana, yes, state no soon. In Article 99, clear say. Those say the state has unfettered access to power, resources, but when you be balance the human rights and then the powers of the state. Yes, I did so. Mammy, I can't once in the court. And my friend say you try no.
Yeah.
Oh, Jane. 1 year cry, 10 years man on 7 years.
Yes.
Of course, however, a specific procedural dilemma arises when an accused person, having been duly notified of criminal proceedings, chooses to abscond.
That's right.
Attorney General say.
That's right.
Adiana mo be ye no. Muni hu say. Adiya ye be mana no. Ya bona man ye se charge ye dia bonini.
Yes.
But we decided to be jane.
Proceedings crash shall say for about 3 years.
That's Attorney General speaking.
That's right.
Leading to a trial and subsequent conviction in absentia. The legitimate question that arises is whether such an individual, now a fugitive from justice, retains the right to utilize the appellate machinery to challenge their conviction while remaining outside the reach of the law. I tell you na point in say.
That's right.
Legitimately the court would say will be on one journey from system na a person punishment system a born a man say or born ya wedding system na man the council on some kind of side of store journey that's fair for that person to come back and use that system to vindicate a position. Okay. That's Attorney General speaking.
That's right.
It goes further to say that before we proceed to discuss the above raised issue, it is pertinent to put this appellant's case in a perspective and state the fugitive appellant is not challenging the procedural steps which were taken in commencing the trial in absentia as not meeting the legal threshold for proceedings in absentia. What she is challenging is the outcome of the said trial. It goes further to say that, my lords, it is right that the right to appeal in Ghana is a creature of statute, underpinned by constitutional guarantees. It provides a mechanism for the correction of legal and factual errors made by lower courts. For a person convicted in absentia, understanding the statutory framework is the first step in determining whether an appeal can be mounted. That is not just filed, but effectively pursued and heard by the appellate body. Into this page, the Attorney General basically goes to the Court Act of 1993, Act 459, to say that, appeal there, because the lower court they try from so. There should be a bigger court who will sit on the matter, and it ends at the Supreme Court, where the appeal process will evaluate the facts and make sure that there is no error. And see, Sedina Tamakloe appeal, the Mramokraman appeal, and will appeal no boss ankruna. Or say under the Court Act, the right to appeal is generally granted to any person who is aggrieved by a decision. This broad language suggests that the status of the person, that is whether they are in custody or fugitive, does not inherently extinguish the existence of the say any panejane. See a channel, or which may appeal, or build a point about the Act provides that an appeal may be on a matter of law, a matter of fact, or a mix of law or fact. Say appeal there, law, ebi a mrano, court here, ebi a fact, when any ebi say a measure of the law and the fact. The appeal there will but your cousin or say, however, after establishing that some prechum court ne butiana, and mrama no hokwan.
So
Act 459 to go to an appellate court. Or say, however, the Courts Act also grants the appellate court the power to regulate their own proceedings and to make orders that are necessary for the administration of justice. This includes the power to strike out appeals that are considered an abuse of the court process. This power, granted the judiciary and the common law fugitive disentitlement doctrine, put together means that once Act 459 grants a right to appeal, the court may refuse to exercise its jurisdiction if the appellant is in active defiance of the law. This creates a situation where the right exists in theory but may be procedurally barred in practice. Also, yes, Ghana manama can say appeal, but who court now better appeal no so. If there's a defiance of law,
that's right.
That's right. You can use that to throw out the appeal.
That's right.
Because there's a defiance of law, and the judiciary must be the custodians and protector of the law.
That's right.
This is Godfred Dominic Attorney General speaking. It goes further to say that it is important to share light on the fugitive disentitlement doctrine at this point. That's what fugitive disentitlement doctrine or say the fugitive disentitlement doctrine is an equitable doctrine which prevents an evasive party from obtaining standing in a court which authority it evaded. Sorry. Or say okuku se kwa frame no one prechum se BBSC.
Me se me ma
ana ofre office. Yuji mebo nkro me na mkobo wo charge. Am prechum mu nipa. Wona ne ye kwa no ahye da dum microphone. O madwuma ntam. Ne fact nye. Ana okuku fr ampre. Yuji ni okani obra. Me ma wo ye hwan. Me ma. Ana wa ama. Ana Attorney General kase fugitive disentitlement doctrine say one man okuku se kwa bu echa say one man dey am suspend 1 year without pay. E mention fa bio. Afa na wo be kase okuku no Eugene kan oboa. Ana Attorney General kase sa dey no ma ho kwan a enye yie o say
because
it's a doctrine which prevents an evasive evasive party from obtaining standing in a court which authority it evaded.
Your friend Renimu Ama, your boy Ebubo on the day I was saying, I feel I'm be defending me.
And I told you, I said, yes, sir. Now goes to say that it limits a person's ability to appeal as long as he or she remains a fugitive. According to the doctrine, an appellate court may dismiss an appeal when the person seeking the relief is a fugitive. It is important to state that Article 11 of the 1992 Constitution, the laws of Ghana, include the common law as well as the rules of law generally known as the doctrine of Yankan said on his own appeal. She was arrested.
Yes.
and or citing authorities any other or citing authorities now no kind. But you see, to conclude for you why I believe the blame is not fair. The Hanokra the Yamakama and West Nanos El Fomu or citing authorities we not say. It's a strike that under our law, a convict who wishes to initiate an appeal must comply specific procedural requirements, the most important of which is the filing of a notice of appeal. According to the rules, of course, a notice of appeal in a criminal case must typically be filed within 30 days of the date of the judgment or sentence. The act of filing a notice of appeal is a clerical or administrative task which notifies the court and the prosecution that the conviction is being challenged. At this stage, the physical presence of the appellant is not strictly required. A lawyer acting under instructions, even if the instructions were given before the client has gone, can technically sign and file the necessary paperwork. It must, however, be stated that filing the notice of the appeal is not synonymous with mounting the appeal. It is a submission that the latter involves the substantive hearing of the case, where the presence of an appellant becomes necessary, and as such, a fugitive status possesses a significant value to the process. Sorry, it goes further to say that, my lord, the jurisdiction of the appeals court to hear an appeal, such as the instant case, is subject to several conditions precedent, some of which are found in statute and others in judicial policy. One of the primary limitations is the requirement that the appellant must not be in contempt of the very court system they are seeking to use. Or say, one of the condition precedents is that the court you are coming under to vindicate your right, you must not be in contempt of that court.
That is I'm presuming
education. See what I say?
That's right.
So that's Attorney General speaking. So how do you blame him? I don't see where you need to blame him. Now it goes further to say that one of the primary limitations is the requirement that the appellant must not be in contempt of the very court system they are seeking to use. It is our submission that the appellant who fled the jurisdiction during the trial and who has avoided serving the prison sentence imposed by a trial court could be viewed as being in the state of constructive contempt. And we urge this court to view her as such. She is in what? Constructive contempt. We further submit that the effrontery of the appellant to mount this appeal when she has conveniently decided not to surrender to the jurisdiction of the court is something that should not be countenanced by this honorable court, as the conduct of the appellant is an affront to the sanctity and integrity of the court.
No shit.
Also, Sedina Tamakloe the new Wasamanka the effrontery kind of saying. Say wonya kukudro court a wobuna nimtia se nya kukudro sa bad judicial system na wobuya nimtia no bepe reprieve. It goes further to say that it is trying that once a competent court of law issues an order, it is expected to be obeyed, except only when the order has been set aside. Now the concluding statement, for me, then I'll leave it to your judge.
Okay.
It is a submission that Sedina's acting defiance of being at large is a flagrant disregard of the judgment and orders of the court that sentence, and as such, this honorable court should not entertain this appeal, as the conduct of the appellant is an affront to the administration of justice. This is appeal court. It may mean who will be person blame Godfrey Dami and answer Dominic Ayene. At the end of the day, as I've always said when I do this analysis, it is a court who will decide.
And I think the court also will take it away seriously, because we know Akwe to say where's now Okano. I know she papa.
In fact, we know who. Who's a panelist number? We know you to form. It's a 43 page. I can forward it to you. If you read it in good conscience, I don't know how you blame either Godfrey. In fact, in challenging the grounds of the appeal, the current Attorney General relied on all the facts of Godfrey Dame. He relied on the fact. Okay. In fact, for me, these preliminary objections that they raise make common sense. Okay. That there's a process. Cameron also sit here. Yes. There's a process that called you that you have questions to answer. This is basically the fugitive disentitlement doctrine.
Yes.
You disrespected that process, and according to the Attorney General, he used fugitive, he used abscond, he used fled. Not even serving a day until you are arrested. How do you come back to that same process to vindicate your position when you are, and in fact, the Attorney General said it here that she was duly notified of what? The charges. This is it. Or say, however, a specific procedural dilemma arises when an accused person, having been duly notified of criminal proceedings,
chooses to abscond, leading to a trial and subsequent conviction.
Exactly.
In absentia.
This is the Attorney General said, you were duly notified. So if indeed you knew these facts were not as it was being presented, why did you run? And that's the Attorney General speaking.
That's right.
So for me, I think that the greatest of respect, I have my issues with the court. But I always say that
that's right.
Some way, somehow, they are supposed to be the ones to do what?
It is in their bosom.
It is in their bosom.
That's right.
So how did, but me, you just said, you know what I was surprised about? It's the 3-0 decision.
Anyway, unanimous.
I was very surprised.
So,
but for me, I think that what the Attorney General done and the posture, it seems as if he's very, very upset by it. Because for him to quote,
and
you see, what is important for people not to know is that when Sedina was extradited, the US statement was very instructive. Now, Jeff, I don't know, say, let me get it for you. Because you see, I tell you, say, one of the things my current lecturers will tell me that you need to do a content analysis of things, and it helps. I'm trying to get you what the court said, the US court said in the extradition of Sedina Tamakloe. It was very, very important. So it tells you that it's not as if Godfrey Dam for say Godfrey Dam Godfrey Dam with the greatest of respect, the US court, the same court I'm believing in, so US is the cathedral of democracy. They said something there. I've sent it to Jeff will project it. But I kind from for say justice has no borders. The US has extradited Sedina Tamakloe to Ghana following her conviction on 70 plus corruption-related charges, including embezzlement more than $6 million, equivalent in Ghanaian taxpayers' funds. This is our strong US-Ghana law enforcement partnership in action, demonstrating a shared commitment to accountability. And the first extradition from the US to Ghana since 2009. In 17 years, a court in the US saw evidence, and based on the weight of the evidence, decided that for the first time in 17 years, they will extradite this woman to Ghana.
Yes.
So based on all these factors, I say I'm surprised. This is why I'm surprised.
Okay.
But that is one. How many minutes more?
Okay. But NC 3-0.
NC 3-0. Okay. Now, the Attorney General press conference.